Bonjour les amis. I hope you are in the best of your spirits and as motivated as you could be to become a part of India's system of governance. Assuming so, let us take 10 more questions to continue to learn that system of governance which you will join one day or are definitely affected by it even today, every day. Now this video is slightly different from all the previous ones, so listen carefully. For the parallel silent quiz of this video, unlike the previous videos with pictures, in this video you will see a popular country's name on the right hand side and you will have to recall or think about the country's system of governance. As in, is it a presidential system or a parliamentary system or whatever else? Is it federal or unitary? And also what is their legislature's name? So, for example, if you see the name of India there, then you should it should bring to your head that India has a parliamentary form of government with a federal setup, and hence, of course, a bicameral legislature, and that a parliament is named the Sansad or simply Parliament of India, and the two houses are Lok Sabha and the Rajya Sabha. Also, if the legislature is unicameral or bicameral, see the first one that I'm going to have on the first slide will be an easy one for practice and warm up. The time you will get is till I'm speaking on the main question at hand. Well, of course, you can always pause and take more time as much as you need. But please do make an attempt. I recommend you pause the video the moment you see the question. Mark your own answer for the main question and the side question, and only then proceed to listen. This will improve a lot of understanding, memory, as well as ability to recall when required. Alright, so let's see the first question that we have. The addition deletion of a language in the 8th schedule of the Constitution of India would require. Now, there's nothing specifically written there, and that's the answer as well, that if nothing is written there in terms of how a specific provision is to be amended in the Constitution, then we know Article 368 applies, and even if you can't recall whether it will require ratification or no ratification, just think about it. Does it affect the federal distribution of powers? Does it affect the division of power? Yeah, the language may relate to a state, but it is not about the division of power as such. So an easy guess would also be that it will require the procedure of 368 and no ratification will be required. So as expected, a lot of you could not, just 1/3 somehow, and this is a very straightforward provision. Anyway, I hope you got the hang of how to look at the parallel learning process here. So for the next ones, brace up. Next question is, which of the following is not essential to have and sustain a democracy? A very interesting question, I find, and a lot of you did get it right, but I see a lot of confusion also remains. For example, this first provision which says political equality of citizens. Now, a lot of argument can be, said that, oh, political equality many years ago was not there in UK or America, and they still were a democracy. The point is, democracy is not a one snapshot in the moment of time, right? Democracy is evolving. The meaning itself is evolving. Of course, these things evolve with time. So even when we say political equality of citizens, you can't have the most, rudimentary idea of equality here. That way, there is no equality. We don't treat adults and non-adults equal, right? So when we say political equality, the one who's 17 and the one who's 18, their political rights are very different. The one who's having a sane mind or not a sane mind is different. So earlier, males and females were treated different. Before that, even those who had property were treated different. So that's a different thing. But the point is to actually say you are a democracy and to sustain it, to keep it running. Of course, this is where it will have to reach, right? It will have to create this kind of a provision. If you have inequality, you really don't have a democracy in the truest form. So your democracy will ultimately evolve to achieve this, right? So if women don't have right to vote, then gradually you will see that the essence of democracy will drive you there, because this is essential to have that democracy, right? So if you think of it that way, the written constitution, of course, if you have a written constitution, it is really good. It will make the rights clear. It will bring the ideas of democracy on the piece of paper. So all that helps, but is it really essential? So for example, you have the United Kingdom, they don't have a written constitution. New Zealand, you don't have a written constitution, and they are definitely considered in the world a more mature democracy than most of the others who have a written constitution. So among the options that you would want to choose, this perhaps would be your better choice. And freedom to protest against government decisions, this I don't even have to explain. What is the democracy where there is no right to dissent? So anyway, B should be your correct answer. So I hope you could get these ideas about United States of America on your own. I'm not going to give you this much amount of time. I'm purposefully taking extra time in the initial 2-3 questions. Good performance. Next question we have is, which of the following statements is or are correct regarding the writ jurisdiction of the Supreme Court and that of the High Court? So let's see. Supreme Court can issue writs for any purpose, while the High Courts can issue them only for enforcing the fundamental rights. Now, this is not correct. I'm sure you know your basic understanding of Article 32 as well as Article 226 will tell you that High Courts actually have a wider power than the Supreme Court. So the High Courts definitely can issue writs beyond fundamental rights. Then second statement says Supreme Court can issue writs against the government while the High Courts cannot do so. I mean, absolutely wrong. This is on the face wrong, because essentially the whole concept of writs, though it can be issued against some judicial officers, it can be issued against quasi-judicial officers at times, but essentially it is to somehow keep a check on the government. It is started in Britain with the idea of containing the powers of the king, okay, so that, or the king's administration rather. So yeah, both High Court and Supreme Court can do that. So your correct answer should be none of the above here. So quickly moving on to the next question that we have. And that is, in case of a joint sitting of both the Houses of Parliament summoned by the President of India to settle a deadlock, the majority required would be. See, these are all ordinary bills that you have, and financial bills also. So all ordinary bills in either houses, unless there is a special provision for some specific situation, the majority that you need is going to be always the members present and voting, the majority of that. Okay, so never be confused. The members present and voting, a majority of that means 50% plus one additional vote to make it more than those who are opposing it. So A should be your correct answer in this. Not that difficult, I hope. And yes, good number of you did get it right. So let's go to the next question, and that is, which of the following items are excluded from the gross tax revenue of the union to derive the divisible pool of tax resources? Okay, and this is the essential, divisible pool through which under Article 280 the Finance Commission makes recommendations as to how much should be the share, which already for this financial year 2021. As I mentioned in the previous video, 41% of the union divisible pool of taxes has been recommended for sharing with the states. Anyway, so customs duties, this will not be excluded. This is essentially there is no tax today of the union government which you will actually think of immediately. Let's say customs duties or corporation tax or income tax, any such thing. They are all part of the divisible pool. They will not be excluded. States federally deserve a share out of it. Okay, now the cost of collection of tax definitely has to be taken out, because that is not going to be a revenue for the union, so it will be an unnecessary burden. So it's taken out, and that is exactly what is called the net proceed of the taxes, which is certified by the Comptroller and Auditor General of India, which is actually a question coming up later in the follow videos. Then cess and surcharges, excuse me, I'm sure you know and you can recall that cesses and surcharges, they are not shared, they belong to the union completely, and that's also the controversial area, because you see there is a lot of focus by the union government to impose cesses and surcharges. Anyway, for the purpose of this question, 3 and 4 is what will be taken away out of the divisible pool. Okay, so moving on, we go to the next question, and that is, bicameralism can exist in which of the following systems of governance? I'm sure you can recall that bicameralism is essential in the federal setup. It is essential in the federal setup, but the question is not asking that. Question is asking it can exist. While in a federal system it will exist, in other systems it can always exist for various reasons. So, for example, if you remember the previous question, if you don't, just roll back the video slightly, you must have seen Bangladesh. Now, Bangladesh is a unitary country and has a unicameral legislature. Okay, the Jatiya Sansad. Whereas, if you see the present example of Japan, if you have not got all the points yourself, please pause and write it on a piece of paper. So, in Japan, it is a unitary country. However, it is bicameral. Similarly, in the UK, it is a unitary country and bicameral. So, there may be various reasons why you may have bicameralism. So, actually, it can exist in any kind of a system of government. Okay, so because it's saying it can exist. Yes, it can exist definitely in all of these. Okay, so I hope you got the point. So the next question we have is, which of the following departments of the government of India administers the matters related to the patents regarding intellectual property rights? Okay, so I'm trying to add. I did try to add during the quiz also at least 1 or 2 questions here and there, where some understanding of the government departments also comes in. Now, this was an easier question. I really don't expect people to be knowing this much in detail, but at least even if you apply a little bit of mind, you should be able to get this answer, right? So, understand patents regarding intellectual property rights. Okay, so now it includes a lot of other things like design and trademarks and things like that. So it's not purely a science, or research kind of an issue which the government is interested in, right? So even just the sense of it, that this actually is going to help protect my the trade and the community of that, and to give respect and the proper rights to the original thoughts and ideas. So even a vague guess should direct you towards option D, that it is the Department of Promotion and Industry and Internal Trade, and that is under the Ministry of Commerce and Industry. So you should know that there is actually a Office of the Controller General of Patents, Design and Trademarks under this department. Office of the Controller General of Patents, Design and Trademarks. So they are the office responsible for managing all this work in our country. Next question we have, which of the following statements is or are correct? So this is actually a very, very important question, and I see a lot of you did not get it right. So please focus some attention. I'm going to elaborate a lot of things here. The most important article here is Article 248. I will sincerely recommend you please read it once. Okay, as I always say, you don't have to read all these articles on your own, but now that you're in that phase of crystallizing and fine-tuning your understanding, read it. You will be very, happy. Sorry, it is not 248, it is 348. I didn't realize what I said and wrote there. So 348, and you will see that it says in the clause 1 itself that until Parliament provides by law anything different, the authoritative text of the bills, acts, ordinances are to be in English. So further from that, the Parliament of India has enacted the Official Languages Act of the year 1963, which has made a provision that the authoritative text in English language of all these bills to be introduced, or the amendments, etc., shall be accompanied with a Hindi translation also. Okay, so yes, this is correct, because this partly is from 348 and partly is coming from the Official Language Act. Further, if you read, the same Article 348 states that, again in the same way, until Parliament makes a law, and this is that law we know, all proceedings, all proceedings in the Supreme Court as well as the High Courts shall be in English language. Right? And the general rule, if you remember, that English will continue only for 15 years, will not apply in the case of the courts. Okay? In the case of courts. Then further, the Official Languages Act 1963 provides that Hindi or the official language of the state may be used for the judgments of the High Court, okay, with the consent of the President. So we can allow the High Courts to have their own language that is used in the state for all their judgments with the consent of the President. Okay, so as of now, several states, you will see, for example, Bihar and Madhya Pradesh, Rajasthan, etc., they have been given the consent to use Hindi. Please be clear that this need of consent of the President is only for the judgments and orders, okay, for the judgments and the orders of the courts. For the proceedings of the court, okay, the proceedings, Article 348 Clause 2 empowers the governor itself, okay. The governor, of course with the consent of the President, but the governor can authorize by a simple order Hindi or any other official language of the state to be used. The law of the parliament is not required. We don't need to make a law in that case, but just for proceedings. And what do proceedings mean? Proceedings include like petitions, appeals, documents, submissions, etc. Okay. If it feels a little confusing, re-listen to the video. You should also know that since last year, that is 2019, the judgments of Supreme Court are now translated in 9 vernacular languages. Okay, so there is a translation of the judgments of Supreme Court, but English is the language that is used in the proceedings. This, was started. The vernacular language translation was started during the Chief Justiceship of Justice Ranjan Gogoi. You may like to see quickly which are those languages. So anyway, both of these are the correct answer for you. So let's move on to the next question, and that is, which of the following provisions provide or protect the rights of tribal population in India? A decently easy question, and a lot of you got it right. So I'm kind of happy that at least, this is a vague guess also. It will be easy. Fundamental rights, yes, we know. They are for everyone, but it specifically protects the rights of tribal population. Lot of provisions are there. But definitely one provision you should definitely be aware is your under Article 19, that freedom of movement can be restricted in the interest of tribal population. Forest Rights Act, we did discuss about it, very, very briefly. There was no direct question on this in one of the earlier videos where we talked about the PESA as well at the same time. So in the Forest Rights Act, lot of power has been given to the Gram Sabha to protect the cultural heritage and the social community rights of the tribal population. Similarly, in the Panchayat also, the Gram Sabha has been empowered to protect the forest produce and the mining, approvals to be given. And Panchayat, PESA also, which is essentially for your 5th schedule areas. So I don't have to elaborate this further. A lot of you got it right, so that's a good thing. So we come to the last question that we have in this video, and that is, a member of either House of Parliament who is a minister, okay, so it's a member who is a minister belonging to a political party, becomes disqualified for continuing as a member of the House. Now this is a question I saw so much confusion on the group going on, so I think let me take some time to elaborate this for you. Okay, see, the first statement is where I think there was confusion. The relevant article here is Article 101 Clause 4. So if you have never read it, please go and read it. In fact, let me bring it up for you here. So if you see, it says that if for a period of 60 days, a member of either House of Parliament is without permission of the House, absent from all meetings thereof, the House may declare his seat vacant. See, there are a lot of things here. First, it is without permission. And whose permission? Permission of the House, not Speaker. Then absent from all meetings. Then the House may declare the seat vacant. So please do consider all these factors. And if then you see, you'll realize that then to say that the member becomes disqualified, it's not a straightaway provision, right? So first, that it must have been without approval. Secondly, if it was without approval, then also the House may declare, they may not declare, and let me tell you, they usually don't declare. What happens generally, you will see also, is that in a way you can say the unauthorized absence is regularized in the form of leave, right? So the House passes that, okay, it may be regularized. So they regularize and, you know, kind of condone the absence part of it. So it's not going to lead to disqualification just like that. So there are a lot of things here, okay? So when it says they become disqualified, no, it's not like anti-defection law, you resign and you are, you know, under the law disqualified. Okay, so the first statement is incorrect. Then the MP has voluntarily given up the membership of her political party. I just told you that if they resign or if they participate in any anti-party activity, then the person, the member of parliament, will be disqualified under the anti-defection law. So second is definitely correct for us. And then a no confidence motion is passed against the minister. Well, I mean, if the no confidence motion is passed, then all the ministers will resign, but they will resign as a minister. Their seat in the House doesn't go anywhere, right? So the third option is not correct. Okay, so okay, not a surprise, but I could see where the confusion is. I hope the confusion doesn't stay anymore. All right, so that's the 10 questions that we have discussed today. As the parting last thing in all the videos, I'm going to bring to you a small quick differentiation between nation and state. I realize a lot of people keep getting confused, so I'm not going to discuss. It's just a quick snapshot. Go and dig up more, but never be confused in the differences between what is a state and what is a nation. And if you understand that, this should not be difficult for you to answer that what is a nation state. So enjoy, have fun, keep safe. I'll see you soon with 10 more questions. Till then, study well. Thank you very much.